morning, I've had a lot of inquiries about the private administrative process. So I'm going to walk you through it real quick on my way to one of the job sites this morning. Pay attention, share this video with many people. It'll help them out. The most important thing in the private administrative process is cultivating a notary. And what I mean by cultivating a notary is finding a notary who's willing to perform their duties and their task as an agent of the state. They're an officer of the court, and to my research and due diligence, I have determined on my own that a notary is in full compliance with the law. And what I mean by that is a proper notary is always independently bonded and insured as they should be, okay? Now, when we go into courts, your lawyers, your judges, your sheriff's department, your police department, so often are not independently bonded and insured. At least in the state of Nebraska, they have this bullcrap bureaucracy blanket bond, which the U.S. Supreme Court has held that the blanket bond is not sufficient. In fact, it is deficient and does not suffice because all agents in the agency are supposed to be independently bonded because they carry a lot of liability in the event that they cause you harm, damage, injury, or loss. So with that said, your notary, being that she has or he has completely been compliant with the law and is independently bonded and insured, is an officer of the court and recognized by the state, and becomes a perfect witness to what you're about to do. So your first step in the private administrative process is going to be cultivating a notary, explaining to the notary exactly what you need them to do, which is keep a record, okay? They're going to create a record, and they're going to keep a record of the things that you are executing. Now, they're a disinterested third party, and the reason I say that is they really don't have anything to do with your affair. So what you will do is you will type up your first notice and demand, okay? It's genuinely going to be a conditional acceptance. If somebody serves something upon you, what you're going to do is do a conditional acceptance, provided that they can prove their claim. Remember, court is held via the mail. What you're seeing in a courtroom, that's all for show. Actual court, everything is decided and settled way before you ever get to court, and here's why. It's a process, ladies and gentlemen. So something that will help this process become a little easier for you to understand. Let's take credit card companies, for example, and collection agencies. The first thing they do is they send you notice and opportunity. You owe us a debt. Most people throw it to the wayside and don't pay any attention, and that's exactly what they're hoping for. Because by you doing that, they're going to continue to move forward with the process. And then they're going to send you a letter of fault. They're going to give you a certain amount of time, maybe 10 days, maybe 30 days, to respond. And when you don't respond, the next thing they're going to do is they're going to send you a letter of fault. Now, the credit card companies and the collection agencies don't often use a notary for this. They're using mailing. They're using the post office as a federal witness to things being sent and received. You'll notice after a while of them sending you something, they'll actually send something to you where they require you to sign for it. That's to prove that you received it. Now there's no plausible deniability on your end. It's just failure to act in a timely manner, which leaves you on the hook. So you're going to send out your first notice and opportunity if you're the one making the claim, and if they're the ones making the claim, you're going to do a conditional acceptance provided that they can prove their claim. And by proving their claim, how did you acquire the debt? Where's the contract with the wedding signature? Can you produce when we embarked on a business venture together? Dates, times, all that stuff is pertinent and absolutely relevant. when you're dealing with a collection agency, they don't like to tell you this, but they bought the debt for pennies on the dollar, and then they're trying to get you to pay a sum greater than that. But the truth of the matter is, you didn't contract with them. You didn't ask them to buy that debt. They did that of their own free volition, trying to make profit, okay? And when you know these things, now you can hold them accountable for it. You can actually send them a thank you letter because you didn't ask them to do that. And they did that for their own proprietary gain without lawful consideration, without you actually giving consent and entering into a contract. So after you do your first notice and demand, the second letter that will go out will be the notice of fault. And that's just you simply reiterating that I served you on such and such day through this notary, and you failed to respond. Failure to respond was tacit acquiescence or tacit agreement that you do not have sufficient evidence that I owe you a debt or whatever the dispute is, okay? You're going to give them 10 to 15 days to respond to that. Now remember, you're giving them a reasonable amount of time to respond. Then your next letter will be your notice of default, okay? When they fail to respond to the notice and demand or the conditional acceptance, when they fail to respond to the letter of fault, then you're moving into default. Okay, now all of this documentation should be personally served by your notary. You can eliminate the post office if you have the notary personally serve it, okay? Now you have a witness who is an officer of the court, properly insured and bonded, that is going to testify on your behalf that she did in fact serve certain documents to the said party and they failed to respond. Now what I like to do with my notaries is I like to also include them in the mailing process. If the recipient or respondent chooses to respond, I also want them to send the notary a letter. This way, if they sent me something and they didn't send the notary, or vice versa, you know, it's just a reassurance thing that I enjoy doing. Because the notary, how you get your notary's license is you're in good standing. You know, you're alleged to be honorable in the state's eyes, okay? So that's why I have the respondent always respond not only to the party who has sent out the first notice and demand, but also to the notary. Then what you're going to do with your default is you're gonna, after the default, you're gonna send out a letter of curation. You're gonna give them 3 to 5 days to cure the default, okay? And you're gonna give them proper notice of that. And once you have completed that process and they have failed to respond and they have not written anything, they have not called you, they have not come to provide evidence and facts, what you're going to do is file that at the Federal Court of Claims, okay? You're going to go before the magistrate on this and you're going to type up your order, okay? Don't make the judge do it. Don't make the ministerial administrator do it. You need to do it. Type up the order, what you need to have done to correct the situation. If it's financial, if it's property, if it's, you know, whatever it may be. You know, maybe the guy owes you a bunch of suckers. I don't know. But long story short, once this process is completed and they fail to respond, you now have the sufficient evidence along with the proper process to go before the court with your notary. And your notary is going to have copies of everything that you have sent to the respondent. Now she is going to go to court, or he is going to go to court with you, and they are going to present the evidence of the process that you executed and what the ministerial administrator is going to do if the party doesn't show up to court. Because remember, court's had via the mail or through private notary. It's already over. Ladies and gentlemen, the summary judgment is already in your favor. It's done. They acquiesced by tacit acquiescence. They didn't contest anything. They can't prove their claim. They've failed to respond in a timely manner. And when they don't show up to court, because court's already over, whether they show up or not, the process has been executed and they have failed. So what ends up happening is you're going to end up giving your order to the bailiff, who gives it to the judge, the ministerial administrator, who will sign off on your order. And then you have one of two options. You can take that order to the local sheriff and have the sheriff, with a writ of execution, go ahead and go ascertain said property, said bank accounts, 401ks, whatever it is, okay? Whatever it's due and owing, a box of suckers. Or you take it to the U.S. Marshals, who's a revenue collection agency. They're collection officers, and you will have the U.S. Marshals go ascertain whatever's due and owing to you, and whether they zero out bank accounts, 401ks, that's up to them. However you need it done to be made whole once again for the trespass or whatever's due and owing. And with that, ladies and gentlemen, I'm going to yield the floor. I'm a few miles from a job, but I wanted to go through the private administrative process with you. The most important thing is cultivating a notary. They need to understand how powerful their position is, because when they become state notaries, they are never taught the private notarial process. They're never taught that stuff. So you have to be able to educate them. You have to be able to show them how to keep a record. You must always pay your notary. This is business, ladies and gentlemen. If you do not pay your notary, and the magistrate asks the notary, well, how much were you compensated? Nothing. Well, then you didn't execute the process properly. You must pay your notary, okay? The travel time, or 56 cents a mile plus time, whatever it is, whatever you come to an accord. Remember, in Article of the United States Constitution, we have the liberty protected and written in stone to contract without government intrusion.